Hello, welcome to our next lecture, Reynolds v. United States. This will be our first criminal case, I believe, which is interesting. That's why United States is named as a party here, and this one may be hopefully enjoyable. It touches on, I think, a lot of interesting questions, philosophical questions with regard to religious freedom and what is religious freedom, and when religious freedom is in conflict with the law, which one has to give, right? Which one has to uh, uh, become inferior with regard to the way the law is going to apply to people. So in this case, to start with the background, we had Mr. Reynolds, who was a member of the LDS Church, Latter-day Saints. He was a Mormon. From doing a little bit of research, it looked like he was pretty high up in the church as well. So usually what that means is that it's a test case. It's a way to challenge the law, and there's a variety of ways this can be put together. But basically, you had the territory of Utah. You had the Mormon church that was up and running out in the Utah territory. And one of their practices was polygamy. To have men were given the right or the opportunity, perhaps, to marry multiple wives. And the Church of the Latter-day Saints have a variety of beliefs regarding polygamy in those times. And part of that belief was that they had free reign. They could, in fact, practice polygamy. But the United States federal government passed a law, the anti-bigamy law. And that's our touchstone here. So I'll go ahead and read that. Every person having a husband or wife living who marries another, whether married or single, in a territory or other place over which the United States has exclusive jurisdiction is guilty of bigamy and shall be punished by a fine of not more than $500 and by imprisonment for a term of not more than 5 years. So the government, the United States federal government, passes this law essentially making bigamy a crime. And now we have the Church of Latter-day Saints with Mr. Reynolds as kind of the guinea pig here because he had multiple wives and it was known, he had witnesses, all that kind of stuff. And so now we're at sort of odds with each other. So on one hand, we have Mr. Reynolds. He has the religious conviction and belief that he can marry multiple wives. And on the other hand, we have the United States federal government that's saying, nope, bigamy is a crime. If you are found guilty of bigamy, then it's punished by fine and imprisonment. So with that being said, we are now at the procedural step. Excuse me. So let me just actually pause right there. This case is kind of weird. The other cases we've read are not necessarily normal, but you'll probably and hopefully see as we go on through the semester that the formatting of the actual judicial opinion will vary. So in this case, there's what's called a syllabus. You can see my little note here. I admitted that syllabus. The court is now going through the background facts of this case, including actual examination that took place in the district court level when it first went to trial, and was recorded in the record of that trial. So that's kind of the first step here. I'm going through the overview of the case just so you know. So when you've already read it or you're about to read it, whatever it may be, this provides the background facts. I touch on the pertinent issues within the case. Keep scrolling. You can see the Q&A, right? Question and answer. And then we get to this little section here, and the court then provides just a brief summary of what Mr. Reynolds' errors are, what he is saying was wrong with the district court and then the Supreme Court of Utah, where they went wrong, and why he is essentially appealing to the Supreme Court to hear his case. And so then when we get through that, that's sort of just a summary. And then this is always key. Look for that opinion, and then where it actually names either the Chief Justice or a justice who's delivering the actual majority opinion for the court. So in other words, these parts may more or less be part of the opinion, but really it serves as help for both the court and for the reader to know where are the background facts, what are the issues at stake, and then what does the court actually think about that. And so the opinion itself is what we'll focus on. But just for simplicity's sake, I thought it was good to go ahead and have an overview of, quite literally the format of the opinion. I know when I first started in law school, we would have cases like this that weren't in textbooks, and so all this sort of additional material was there, and I would get lost. And what is this? So if you have ever had questions about this, please let me know. Again, email me with any sort of questions. I want to make sure that when you're actually reading the material, you can start grappling with the arguments and the logic and the analysis, the rhetoric that's used as well, rather than get bogged down with kind of the legalese, the technical jargon here. Okay, so we are now at the procedural. So we know the background, right? We have Mr. Reynolds high up in the Mormon church. He is practicing bigamy, he has 2 wives, and the United States federal government has passed a law that says bigamy is a crime. So now he is being prosecuted, right? He's under prosecution for a crime, the crime of bigamy. District court finds him guilty. He then appeals it up to the Supreme Court of the territory of Utah, which would be the next appellate stage. They uphold that conviction, and so now he's appealing to the United States Supreme Court to say, and it's really his court of last resort here. They're going to have the final say on this matter, and so the issues presented, I can scroll down here for just a second, are threefold. One, whether the jury was properly impaneled, or whether the jury members were properly selected. 2, whether Ms. Schofield, which is, I believe, one of his wives, I think that's right, one of his wives' testimony from the former trial that he was a part of can be included in the current trial, even though she wasn't there to take the stand. So that's the second issue. And the third issue, and the one that hopefully we'll spend the most time on, is whether the federal law, the anti-bigamy law, was constitutional in light of the First Amendment. So let's scroll back up, cover the background, we cover the procedure, and so now let's just start getting sort of the nitty-gritty facts that'll help us when we look at the 3 separate issues that the court looks at. So for Dyer, it's probably said in a variety of different ways now that I think about it. In Texas, we say voir dire, voir dire, perhaps. It could be said in a variety of ways, but it's the process where the jury members are selected. So kind of zooming out real quick, adults today are still selected to serve on juries. They're not always actually selected. There's hundreds that are potentially called out to have or to serve on a jury panel, but there's a certain process that's involved. It's a numbers game. So, for example, if one of your parents has ever been selected for jury duty, the further away they are from the top, more or less 20 spots, the more likely they will not be selected. Now, if they actually make it into the room, there's usually a certain amount of people in that room, but there's only going to be 12, for example, jury members. Depends on the jurisdiction, but for simplicity, let's just use 12. So during for Dyer, the attorneys basically get to ask questions of potential jury members to figure out whether they are impartial, whether they are biased, whether they have certain proclivities or otherwise opinions that would inhibit their service as a jury member. So in other words, if someone comes into this case, going back to Reynolds v. United States, and has this deeply held belief that bigamy is absolutely God ordained and is a fundamental right, and the United States would always be wrong, regardless of what they said about the laws or bigamy or anything like that, then they would be considered biased, and the prosecutor for the United States of America would not want that person on the panel. Why? Well, it's already a vote against him, right? It's already a vote against his case. Likewise, if you already had certain people on the panel that just were disgusted by Mr. Reynolds and could by no means understand why in the world he would have 2 wives and why in the world he would be a Mormon and practice those beliefs, then the defense attorney likewise would not want those people on the jury panel, right? They would be considered biased. They would have existing opinions, and so they would say, nope, let's get them off, and they would try to strike them. So there's different ways that you can get a potential jury member out, not have sit on the panel. For our purposes here, though, it doesn't really matter. Only thing we really need to focus on is this kind of question and answer. So when you read through this, think through that sort of lens of, okay, well, if you were the defense, right? If you were the attorney representing Mr. Reynolds, regardless of your personal beliefs, right? You are the attorney, you're situated, and you have to get a fair and unbiased jury panel. What sort of questions would you ask, right? How would you figure out certain biases and opinions that were held? And that'll hopefully start making more sense, because that's one of the main points, right? One of the main issues that the defense attorney brought up was that these people had opinions already. So they were already biased, and they were going to be prejudiced against Mr. Reynolds. Okay, next. So that's sort of like the first section there. Next, we have Deputy Marshal's testimony regarding trying to find one Miss Schofield. So it kind of gets ticky-tack here, but basically the marshal shows up with a subpoena to say, hey, you are going to need to come to court and give your testimony, and she can't be found. And he knows her. He knows that it's her personal residence, yet she can't be found. And then the defendant there is able to say, well, best of luck, man. If you want to find her, you got to go find her. I'm not going to tell you where she is. Strategic, perhaps, right? if her testimony would basically be, yep, I knew he was married to the first lady and I still married him, or he told me he was married and I still married him, or whatever it may be. Not great testimony for the defense, but it may be sort of beside the point. We may not really care what the testimony is. It's the fact that she was going to be called as a witness, Miss Schofield. The marshal went to deliver the subpoena, which is just a summons basically saying, hey, you got to show up at this time to do this thing. If the defendant, Mr. Reynolds, is hiding her and she's going to give adverse testimony or whatever it may be, then that's potentially an issue, right? We want the truth to come out in court. We want everyone that would have any sort of information about this given issue to be there, right? To be witnesses and to be able to speak to a variety of issues and questions that they may have information to. So that's their exchange there. That'll come up later. And then let's scroll down to the jury instruction. So the jury instruction, very important. The way that I typically approach cases in my practice is I think about all the way through. If this does go to court and I have to sit there in front of a jury, what do I want the judge to instruct the jury on? What sort of issues and presentation do I want the judge to have to say to the jury? This is the question you're deciding. So the jury instruction is very important. Here, the defendant was trying to make the argument that, look, if I have a religious belief about polygamy, then I can't be guilty of this crime. Why? Well, my religious belief is protected by the First Amendment. Therefore, under the guise of the First Amendment, I cannot be guilty of practicing my religion. Court says no. Court just said, nah, not going to cut it. The religious belief would imply criminal conduct. And so the judge, instructed the jury accordingly. So in other words, your religious belief does not excuse the criminal conduct. The way that the jury will be instructed is whether I think it's right here too, he had deliberately married a second time, having a first wife living, in the want of consciousness of evil intent, the want of understanding on his part that he was committing a crime, did not excuse him, but the law in such case implies criminal intent. So, in other words, he knew he was doing the crime, right? He knew he was committing bigamy. He knew what he was doing. So even if he had a religious belief, that would still show criminal intent. And so the judge instructed the jury accordingly, and that'll kind of be the heart of the main issue of this case, right? Whether that federal law, the anti-bigamy law, was constitutional. So, he's guilty. Jury finds him guilty. He had 2 wives. Kind of open and shut case. Mr. Reynolds appeals to the Supreme Court of the Utah Territory. Same thing. They uphold the conviction. So now he's appealing to the United States Supreme Court as far as he can go. Okay, so we kind of talked about this. This now is a brief summary of the errors that Mr. Reynolds, and it really is his legal team. When I say Mr. Reynolds, it's his attorneys representing him. But Mr. Reynolds is basically petitioning to the court, saying to the court, hey, the lower courts got these things wrong. And because they got these things wrong, then my conviction needs to be overturned. And if not overturned, then perhaps a new trial. There's a variety of ways that could provide remedies. But for this case, these are the 3 main issues that we touched on a moment ago. So the first issue is whether that jury was properly selected. The argument that he makes is basically, look, they already had opinions. They already had biases that went against me and my deeply held religious convictions. Because they were already biased, then they were improperly selected. They were improperly drawn. And because of that, I didn't have a fair trial. Second issue, whether Ms. Schofield's testimony at former trial should have been admitted as evidence of this trial. So in the, the 6th Amendment? Always consult the Constitution. Keep it handy. Yes, okay. In the 6th Amendment, there is a right to confront the witness. So that is a guaranteed right. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So, in other words, if someone is going to present testimony, right, evidence of a given matter, the defendant has the right, provided by the 6th Amendment, to confront that witness. So, in other words, to cross-examine that witness. If the witness is saying, I saw him jaywalking across the street at this time of the day. Okay, well, jaywalking may be a misdemeanor or whatever. Let's just continue with that analogy. So if you're being accused, then you have the right to then go and say to that person who's saying or providing this testimony about your crime, hey, weren't you actually at work at that time of the day? Or, hey, haven't you been telling me that you haven't got your glasses prescription updated in a number of years? Whatever it may be, right, to cause doubt on that testimony. There's a constitutional protection there in the 6th Amendment. So that issue of whether her testimony could be used at trial, even though she wasn't there, is that second issue. And then the third issue, of course, is whether the federal law exceeds its power in violation of the First Amendment. So you have the anti-bigamy law, but you have the First Amendment that guarantees the free exercise of religion. So if someone is freely exercising their religion and it runs afoul of a federal law, shouldn't the federal law have to go, right? Shouldn't someone be able to practice their religion freely despite this federal law that would otherwise inhibit them from doing so? Okay, so those are 3 issues. Scrolling down now, like I pointed out before, opinion. That's how we know, getting to the meat of the situation. But the background's been set. The stage is set. Now we're ready to dive in. Okay, so let's see. Assignments of error. Like I said, defendant's complaining to the appellate court here, Supreme Court, of what basically the district court and the Supreme Court of the Utah Territory did wrong. And so now he's got to make these arguments as to why they're wrong and why this should be overturned. So the first one is regarding the impartial jury that we'll touch on here. Very important, right? We talked about that. Impartial jury is crucial. It's a bedrock principle to be able to have a fair trial. If you have everyone on the panel that already hates you, has already made up your mind about your guilt, then you're not going to have a fair trial, right? We want an impartial jury, and so that's really what the court's looking at here. You'll have read the case, and so it's just important to kind of focus on these highlighted sections. But basically, what the court gets to is, look, you can't have a truly impartial jury. You can't have people that aren't influenced or have any sort of understanding, perhaps, of the case in the light of today's times. There's a good quote in here about, in these days, newspapers, enterprise, and universal education, every case of public interest is almost as a matter of necessity brought to the attention of all intelligent people in the vicinity. So people know about it, right? That's not a sufficient reason to... I just froze there. Apologies. Just because people already know about it or may have heard about it, and that's that Q&A that the examination touches on, doesn't mean they necessarily have the bias already. So they may have heard something and heard murmurings and may have heard that this guy may have had 2 wives, but who is this guy and do we know that? And they may have gone off for their workday or may have had lunch or just completely forgot about it. So just because they heard about it or may have been seen it in the newspaper doesn't necessarily mean they've already formed this bias that would otherwise inhibit them from serving on the panel. So that's the first issue there. Okay, moving on to the second issue now. So whether Ms. Schofield's testimony can be heard from a former trial at this current trial, even though she's not there. So court says Constitution gives the accused the right to a trial at which he should be confronted with the witnesses against him. Right, the Sixth Amendment just read. I wonder if you can hear that thunder right now too. If it picks up, it picks up, but got a good thunderstorm going on right now. Anyway, yes, sorry. Right to a trial at which he can confront the witnesses. But if the witness is absent by his own wrongful procurement, he cannot complain if competent evidence is admitted to supply the place of which he is kept away. So this is a common law principle that they get into in this paragraph here. Again, it says, so quoting this Lord Morley's case, again, those reporters we talked about, how they were collected of opinions. This is way back in the day. 1666. There you go. It is laid down that if a witness is kept away by the adverse party, his testimony taken on a former trial between the same parties upon the same issues may be given in evidence. So in other words, we want defendants to be able to confront their witnesses, right? If the witness is going to say something bad about them in trial, we want that witness to be in the court so the defendant can actually confront them. That's a constitutional protection. Here's the thing, though. If that same testimony was previously given, right, between the same parties, same sort of issues, then we're going to let that testimony come into the second time, right? Why? Well, you already had the opportunity to confront that witness. You already had the opportunity to tease out the truth from hyperbole or lie or whatever else it may be, exaggeration, at the first instance. So, you get the right to be confronted with the witnesses against him, for the witnesses to actually be at the trial. But if the witness is absent by his own wrong procurement, so in other words, Mr. Reynolds perhaps kept Ms. Schofield away from the second trial, he cannot complain if the competent evidence is admitted to supply the place of which it has been kept away. The rule has its foundation in the maximum that no one shall be permitted to take advantage of his own wrong, and consequently, if there has not been in legal contemplation a wrong committed, the way has not been opened for the introduction of the testimony. So, look, you already had the opportunity in that first trial to sort through that evidence, sort through the testimony, figure out what's true from what's not true. And moreover, if you're keeping the witness from testifying, not necessarily physically, it could just very well be a understanding of you're not going to go there, you're not going to be able to benefit from your wrong. So tension there between the Sixth Amendment and the adverse party keeping the witness away from testifying. Second issue is resolved. Her testimony is going to come in, and that's going to be that. That's how the court's going to resolve it. So now on to the main question of the case, whether religious belief can be accepted as a justification of an overt act made criminal by the law of the land. So the question to be determined is whether the law now under consideration comes within this prohibition. Hopefully the tension is there. I can set up the scene a little bit further where we have the First Amendment, right? We have the First Amendment that's going to provide for, actually I'll just read it. Congress shall make no law respecting an establishment of religion or promoting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So Mr. Reynolds is basically making the argument here that, look, you're prohibiting my free exercise of religion. The Constitution provides that I have a right to freely exercise my religion. This federal anti-bigamy law inhibits or prohibits my free exercise of religion. Therefore, it's unconstitutional. Situated again in the context of he just committed a crime, right? The law was passed. No bigamy. If bigamy, then prison. He did bigamy, so now he's going to prison. And he's saying, wait a second, guys. I know it looks like I'm a criminal. I know it looks like I broke the law, committed a crime. But my deeply held religious conviction says I can practice bigamy. So if the government steps in and says no bigamy, they are prohibiting the free exercise of my religion. And because they're prohibiting the free exercise of my religion, this law is unconstitutional. And because it's unconstitutional, then basically throw it out, right? Throw out the case. United States argument, right? Important to keep that in mind, not to lose sight of the common sense approach. The United States passed a law. It said, if bigamy, then prison and fine. Bigamy is a crime, in other words. That's it. That's their argument. Here's the law. It was passed by Congress. You, Mr. Reynolds, sufficient evidence that you have multiple wives. You are guilty, or we're going to prosecute you for bigamy. The jury, right, of your peers, it wasn't like they just said, yep, that's it, right? Still had the right to a jury. The jury at the trial still said, yep, guilty. And then the Supreme Court of Utah Territory also upheld that conviction. So how do we reconcile these competing notions? Religious freedom, federal law. Religious freedom, federal law, when they come head to head, how do we resolve this? Well, the court starts by asking a very, I think, appropriate question, is what is religion? We don't have the definition in the Constitution, so they say we must go elsewhere, therefore, to ascertain its meaning, and nowhere more appropriately, we think, than to the history of the times in the midst of which the provision was adopted. The precise point of the inquiry is, what is the religious freedom which has been guaranteed? We saw this before, right? We saw this before where in Dred Scott v. Stanford, they asked themselves the question, what is a citizen, right? What is a human, really? All men are created equal, but what do they mean when they say all men? What do they mean when they say citizens have the rights and immunities and protections of the laws of the United States? Court basically does the same analysis. If you remember, too, it's probably been a couple weeks ago, if I get my timeline right, the food in the kitchen case, right? What is food, right? What are we going to define food as? And only then, when we have the actual definition of the word, can we then proceed. So I think this is an appropriate starting point here, rather than just kind of immediately get to, oh yeah, he's going to say it's a religious freedom, and religious freedoms are protected. Therefore, this law is violating his constitutional right to practice, to exercise his religion. The courts can say, wait a second, what even is religion here? So they look at the analysis here of what the historical context of religion is. Again, you'll read that, and then we'll double down and double click here on the Thomas Jefferson quote that's really important and really what the court kind of ultimately concludes with regard to its analysis of religion. So in this quote, Mr. Jefferson says, believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legislative powers of the government reach actions only, not opinions, I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. So they use this quote to sort of situate themselves in the mind of the framers when they're thinking about religion. So when they put together the First Amendment, they're thinking about, okay, what do these guys think about religion? And here, what seems to be the case is that there's a difference between religious beliefs, right, which lies solely between man and his God, that he owes no account to anyone else, and the legislative powers that pertain to religious actions. So religious beliefs between you and God. Religious actions, though, are within the purview and the reach of the legislative powers of the government. Okay. Good bifurcation there. Good delineation. Good separation of when we're thinking about religion and we're thinking about the First Amendment in particular, saying that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The government was really thinking, we're not going to prohibit any kind of religious beliefs or opinions. That is within your personal, subjective, individual purview. What you want to believe with regard to religion or God, faith, anything else that may roughly touch on that big concept of religion, that's on you. However, actions, tangible, overt acts, that belongs to the legislature. So you can go and believe whatever you want to about anything. That's apparently what is okay. As soon as you start acting on those beliefs, though, that's where things are going to change. That's where the legislature is going to draw its line, and that's ultimately what the court is saying the law is. So how does that pertain to us? Well, Mr. Reynolds, if you truly believe that God has ordained bigamy, and you as a male member of the Mormon Church needs to or is entitled to, whatever it may be, multiple wives, then you can have that belief. By no means can the law, can the federal government come down and say you can't believe that, or you can't have an opinion about that. However, as soon as you start practicing, overtly acting upon that belief, that is where the federal government can step in and say, actually, that's within our purview. So you can believe it all you want, right? You can have that deeply held conviction. However, by passing this law, we have said that bigamy is a crime. So if you may very well believe that bigamy is perfectly okay, but as soon as you marry another woman while still being married to your first wife, that's that. That's a crime. We're drawing the line there. That's the way we're going to separate and bifurcate these two things between religious beliefs and religious opinions. So then the court basically goes further. That's how they're reconciling the concept of religion. And then they're starting to go further within their analysis to say, okay, where else has polygamy shown up in the world's history? So they go through a historical analysis here that generally speaking, it's always been odious among the northern and western nations of Europe until the establishment of the Mormon Church. And it was almost exclusively a feature of the life of the Asian and African people. And at common law, the marriage was always void. So they go through this analysis, they look through the common law, and they say, this has never been protected. This has not ever been a fundamental right. This isn't like we have had it around forever, and then the federal government arbitrarily drew a line in the sand to say, actually no more. It's just never been around until the Mormon Church got here. Maybe in some other cultures as well, that was fine. But at least where we derive our law from, English law and the common law, no. right? They're going to look at the historical analysis and say it doesn't show up anywhere. We're going to keep moving on. We're okay with this separation of religious beliefs from religious actions. It's never shown up in our common law history. And then this is kind of the conclusion here. Laws are made for the government of actions, and while they cannot interfere with mere religious belief and opinions, they may with practices. So again, that's now the line in the sand between beliefs and opinions, or excuse me, beliefs and actions. You can believe and have the opinion to really whatever you want to. As soon as you start acting on that belief in a way that violates the law, that's what the law comes down and says, nope, that's it. That's going to be the crime or whatever else it may be. They use this what I call a slippery slope argument. If you have a better way to tee up this argument, then please let me know. It may be on one of the reflection questions as well. But the court basically looks at this further and says, what are we going to do with someone that says, yep, got to sacrifice humans? What are we going to do with a widow that needs to throw herself on her husband's funeral pile? What are we going to do about that? Surely the law would step in and say, we're not going to sacrifice humans in the name of religion. And surely we're not going to let widows kill themselves by throwing themselves upon the burning funeral pile. Surely the government will come in and step that. So basically, if and this is kind of to sum that up, to permit this, right, these other instances of religious beliefs that would overtly violate the law, if we permit this, would be to make the professed doctrines of religious beliefs superior to the law of the land, in effect to permit every citizen to become a law unto himself. Government could only exist in name under such circumstances. Really, really important point here. I wish I had a better way to draw this out. I wish they would spend more time here. But it's this concept of you're looking at the objective law, right? The tertium quid, the third thing that we're going to appeal to when we're looking at laws. We're going to say, this is it. This is the objective reality that we're all abiding by. If all of a sudden this gets to be undermined by saying, you know what? Actually, I have this belief, or actually I have this opinion. What do we do about the supreme law of the land, right? The Constitution gets thrown out. If all of a sudden my religion says that, this Constitution does not abide by me, I'm the non-constitutionalist denomination. I wonder if there's one out there. But anyway, this gets tossed, right? And so then all of a sudden, all this whole concept of the rights that were protected, the systems that were set up, any sort of laws that the United States passes down, or your respective jurisdictions, right? In Texas passes down the law, it goes out the door, right? All of a sudden, we don't have anything to uphold. We don't have anything to abide by. There's no third thing to appeal to say, no, this is what we're living by and under and for. It's just anyone's religion unto himself. Every citizen becomes a law unto himself, and so the government can no longer exist under these circumstances. So let me touch on this real quick. If this is kind of shaking some cool things up, and you're interested in this question of religious opinions versus practices, and where the Constitution comes into play and how they resolve these issues, there's an interesting case out there that I recently learned about animal sacrifices in the name of religion. So if you're curious about this at all, there's a link to the case. You can read the opinion, you can read the summary, whatever it may be. But here, the court clearly delineates, or it clearly speculates that, look, we're not going to allow human sacrifices in the name of religion. We're not going to allow widows to throw themselves upon their dead husband's funeral pile out of religious devotion or whatever else might be. But what about animal sacrifices? Right, that's kind of a head scratcher there. Old Testament, right? All the animal sacrifices that took place then and there under the Old Covenant. So what do we do about that? What do we do about religions that would say animal sacrifices are necessary for religious devotion or otherwise? So there's that case there. We touched on sort of the difference between the objective law and the subjective belief. If anyone at any point in time can just claim my religious belief allows me to do this, this, or that, I get pulled over speeding, and sorry, officer, I'm of the whatever, fast church, and we believe in a, speed limits of 100 miles an hour, or whatever it may be. That's not going to fly, right? We're going to have laws in place that everyone is subjected to be the supreme law of the land. So if someone says, my religious belief would enable me to do whatever kind of action, government would cease to exist, society would fall apart, chaos at every turn. But we still have the First Amendment. So beliefs and opinions, sure, go crazy. But as soon as you start acting on those beliefs and opinions, that's where the legislatures can come down and start saying either, nope, we're not going to allow this, or, as we've seen in more modern times, yeah, we're actually going to protect those actions that come from those beliefs or opinions. We'll touch on that probably in later cases. Again, we're in 1878 right now. Kind of interesting foreshadow of today's times. But all to be said, when we're now getting back to the nature of this case, it's still a criminal nature at heart. So, Mr. Reynolds has to have two components to commit a crime: a criminal intent and the actual action. And I believe it's Latin. Surely it is. Mens rea and actus reus. That combination is what actually commits a crime. So it's not so much that it's just the act. It was the intention behind the act. I don't know if we'll have a murder case, but that's an easy one to pick on. That there's different mens rea for murder. So if you intentionally kill someone, that's one crime. But if you accidentally kill someone, that's another type of crime. So the action remains the same, namely that someone has died, and we as a society have to do something about that. But what sort of intent was behind that action? And that ultimately gets to that crime. So court concludes, where therefore he married the second time. So when Mr. Reynolds married the second time, he is presumed to have intended to break the law. And breaking the law is the crime. Every act necessary to constitute the crime was knowingly done, and the crime was therefore knowingly committed. So in other words, really because he had that religious conviction that bigamy was okayed or ordained or encouraged or whatever else it may be, because he had that belief operating, there was that knowing, that intent behind the crime. So in other words, if he just said, you know what, let's just say he has no connection to society whatsoever, there's no understanding of the law, whatever it may be, and he's marrying multiple wives, that would still be a crime, right? That would still be the act that the law is out there. And the law may look at that situation a little bit different to say, okay, now did he know that? Did he knowingly commit the crime? So sure, we still have the act, namely that there's two wives, but what sort of mens rea component was involved in that crime? That's the answer that we may get into for other cases. But for now, that's really what the court looks at and says, look, your whole argument about religious devotion and religious freedom and the right to practice your religion shows that you knew you were breaking the law. You had the intent to break the law. And then as soon as you married the second woman, you broke the law. So knowledge, intent with the actual action, right, the mens rea and the actus reus put together means that you committed the crime. So that is it. That's it for this case. Shorter case, of course, not 200 pages like our last one was. But hopefully it sort of wrestled with some interesting concepts of what is religion, how is religion defined, what's the difference between a religious opinion and religious belief, at what point in time can the government step in, and then kind of the sub-issues up here too regarding to impartiality for the jury, and then what sort of rights are available to a defendant to confront his witness in trial. That's it for this case. Shorter lecture, of course, but hopefully it'll give you time to maybe have some discussion in the class or start working on the questions for this week. I pray that you have a blessed week. Hopefully that this will spark some great conversations, some great discussion, answers, and maybe conversations too throughout your school and church and community, wherever else it may be. But like always, any sort of questions about the case, anything else, reading the case, assignments, whatever else it may be, please send me an email. We'll get that answered and squared away. I want this to be helpful and valuable to you. So if there's something and you're not even sure what it is that's missing, but something's just not clicking, we can talk that through. We can figure it out. I'll see you next time. Thank you very much.